What's up, everybody? Welcome back into another episode of The Lawyer You Know. And today we are going to be reacting to and breaking down today's hearing, which started out incredibly explosive and combative and pretty much didn't change that vibe throughout the hearing. A lot of misconduct to go through, a lot of admissions made, which will be really interesting to see how they'll affect what the judge's decision is and how we continue forward in this case. But the one very important question that we all have to keep in mind throughout this entire video and this entire process is the evidence exculpatory? Is it material enough for Judge Cannoni to actually make this call? So let's answer your questions. Let's watch some clips of this hearing together right now. All right, so stuff is ever changing in this case, and more stuff is trickling out. And I know one of the jurors came out and spoke, and I think we've gotten comments from her in the past, and nothing is really surprising to me that we're hearing from the public sentiment of what's going on in this case. And the overarching theme of today's hearing, from my perspective watching it, is it just gets worse and worse with how this case was handled, how the investigation was done, how everything was tracked, how everything came out and trickled out throughout trial, how this is just not how it's supposed to be. And then at the very end, Hank Brennan agrees with me, with you, with everybody that feels that way. And I felt like that was a pretty big admission, because while he makes a decent argument as to why, even though that's the case, the judge should not dismiss this case for what we're going to talk about today in the hearing, his admission there could still potentially be so much bigger when it comes to the ultimate decisions the judge makes in this case in the interests of justice. But we need to talk about this. Is it so clear cut? Is this misconduct so obviously exculpatory? Would any judge in America dismiss this case at this point? Let's take a listen to what happened in the actual hearing and see if we can get some answers to those questions. We're going to jump in right at the beginning of the hearing, where the judge is going to call out Attorney Jackson by his own words later and go at him for something he signed under oath. Does he know that it's not true, what he's putting before this court and signing under oath?
Governmental misconduct are true and correct to the best of my knowledge, signed and sworn to under the pains and penalties of perjury this 21st day of February 2025. So the fact, what you state is fact, that Lieutenant Fanning had control over and access to this jury is simply not true, Mr. Jackson. The only people who have...
That feels like the judge testifying right off the bat. You saying that Lieutenant Fanning has this is just not true. Okay, how is the defense supposed to know that? Right? Is she imputing knowledge on the defense? Is this something that she knows, obviously, because she works there and in that courthouse and is somewhat in control of that jury? Is she telling the defense that now? Interesting, just right off the bat.
Any access to those jurors are the court officers in the Department of Security of the trial court in this courtroom. So I am going to ask you what your good faith basis is for that, and I'd like you to start there.
If the court recalls the discussion at sidebar, we were told for the very first time, Your Honor, about this issue concerning the juror and concerning the individual who reported information suggesting that there was some sort of misconduct at sidebar by the court with no additional information.
No, I didn't tell you about the role. I didn't know who it was.
I'm getting to that, because that was the next conversation.
It's like, Judge, chill. Let me make my argument. Let me make my argument, Judge. It's cool for judges to pop in with questions, but once they throw some kind of accusation like that at you and they ask you a question, it's like, I need to answer that question before we move on to the next point.
We had, when we were told on the day of closing argument to approach sidebar, the court indicated through multi-level hearsay, we'll all agree that it was some sort of multi-level hearsay suggestion that there was some sort of misconduct by the jurors, or by a specific juror. We pressed the issue at sidebar and asked who the source was. At that time, for the first time, we were told the name Lieutenant Fanning. We obviously
You were not, just so we're clear, you were not told that by me.
No, we were told that by, and I'm getting to that as well. We were told that by Ms. McLaughlin. She's the one that indicated that it was reported. I'm sorry. That's not right. That's not right. We pressed the issue on who was the source. I believe the court then inquired of...
Little has so many of the answers here in the bottom corner of the screen. You can kind of see when she looks back at Jackson, it's almost like a hint, like, hey, That's not what it was. And she's got a lot of the answers and dates. And I just think it's so funny throughout the process how she's done that. Tracy, thank you so much for gifting 20 memberships. Feels like it might be a big gifted membership stream. So everybody make sure you have it turned on where you can accept these memberships.
One of the court officers.
Who are in charge of the jury.
Your Honor, I'm getting to that. I understand that. But if you'll allow me to make the argument and to indicate what as my declaration says, my good faith belief, based on reasonable belief, this is how we get there. We were then asked, or the court asked the court officer to join us at sidebar. He then indicated that it was Lieutenant Fanning. Ms. McLaughlin then went on to say, and by the way, he indicated that Lieutenant Fanning had reported this, supposedly gotten it from some unnamed or unidentified person. There was no evidence presented at the time, as the court knows. There was no declaration, there was no report, there was no supporting documentation whatsoever, no recording, even though this report to the court through the court officer from Lieutenant Fanning indicated that this juror may be, quote unquote, may be on a recording. And the court confronted that juror with that information. There was a brief colloquy with the juror where she said, not that I remember. No, that was the initial statement that she said in terms of any misconduct. No, I wasn't talking about the case. Over the defense's objection, this very potentially defense-friendly juror was then excused. During that discussion at sidebar, that's when Ms. McLaughlin explained for the very first time to the defense that who Lieutenant Fanning was in this circumstance. And she said that he was the, quote, commander of the extensive security operations that this case has required, period, end quote. That sentence says a lot. It said a lot to me.
It does not say he has access to or control over the jurors.
It says that
And
he
I'm
has,
just going to stop you. I'll let you finish in a minute.
Okay.
Mr. Yanetti, as a Massachusetts practicing lawyer, knows that the court officers are in charge of the jurors. Go ahead, Mr. Jackson.
if there is,
Like, that's not how we do it around these here parts, Mr. Jackson, city slicker from LA. It's like, and later on, by the way, Yanetti's like, that's not quite how I do not agree with you, Judge. She says Yanetti's going to back her up all the time. Like, we both rep the same smart tech. And a lot of times Yanetti's like, no, not really, Judge. Not really. I don't know that to be true. And as we're going to learn throughout this case, we've been saying so often in so many cases, the defense does not know what law enforcement knows. The defense does not know what the prosecutors know, right? We are on the outside as defense attorneys, and a lot of us know that because we used to prosecute cases. So we know the difference.
is a commander of the extensive security operations over the entire case, there is, Your Honor, no greater security operation than securing the jurors. That is sacrosanct. It's paramount among the security operations that the court embraces. And we were told, I didn't make it up, Ms. McLaughlin told us, we were told he was the commander, not part of the security operation that was outside the court, not part of the security operation that helped parking cars or making sure that citizens got in and out of the courtroom appropriately. We were told he was the commander of the extensive security operations in this case. It is reasonable to conclude from that statement that Fanning was either directly in charge of the jurors, which the court is now telling me he wasn't. Again,
You were told that at sidebar
No.
that day by Ms. McLaughlin.
No, we were not. We were told.
I have the transcript.
Well, Your Honor, what we were told is what his title was, commander of the extensive security operations of the court. So we reasonably concluded that he was either directly in charge of the jurors or in charge of the people who were in charge of security of the jurors. But we were never allowed the opportunity to find out exactly what his role was because the court didn't take evidence, refused our request at the time in good faith. Both Mr. Yanetti and I asked the court to take evidence from Lieutenant Fanning. The
I think
court
it was
declined.
Absolutely should have. If you have a juror issue, put it on the record. What are you scared of? I don't understand what these people are scared of. And that's one of the biggest things that experienced criminal defense lawyers. I remember one of the first cases I ever tried with my dad. I was like, geez, Dad, you're really fighting with this judge about everything. And he's like, it's got to be on the record. Either it's on the record or it didn't happen. In our generation, it's PICS or it didn't happen, right? It might as well have not happened. And then as you see so much in this case, and it's going to be something I say a million times throughout this video, is each side sees it the way that they see it. What does that mean and how important is that legally will depend on what we're talking about. But it has to be on the record because if it's not, then you have stuff like this where everybody's saying, oh, that's not true. That's not how it happened. That's not how I remember. You knew he wasn't in charge of X, Y, and Z. It's like, if you would have let me ask him questions, then maybe I would have known that, which should lead us to one of the things that could happen at the end of this whole charade, which is we have an evidentiary hearing to get more information. And we're going to talk about whether or not we think that's necessary.
Little.
I'm sorry?
I think it was Ms. Little who asked me to.
And what was the court's response? The court's response was to decline that invitation. We didn't take any evidence, which would have drawn down on the issue. So I wouldn't have to make reasonable conclusions. I would actually have the information. So of course, that's one of the issues that is attendant to our motion to dismiss because it seems wildly inappropriate. Here's what we do know about Lieutenant Fanning. Once his name was uttered, here's what we didn't know. He's among the troopers.
And this is stuff I heard, but I didn't know. Jackson's going to put it in the record. And I don't think anybody really corrects him except for Brennan later to say Fanning's a great guy, utmost character, love him, he's the best, which is fine. And maybe that's true, but he didn't say what Jackson says right here is untrue. So this is the first time we kind of hear it come out in court. Nobody corrects him. So at this point, I guess I can kind of believe this as truth, what he's saying about Fanning, which is concerning. Mom to 8. This is a big question that we're going to answer in the hearing. I will definitely answer this as we go, but I want to listen to what actually comes out to see if an evidentiary hearing is actually necessary.
That is one of Michael Proctor's supervisors. He interviewed several prosecution witnesses who testified at trial against Miss Reed, including Laura Sullivan, Marietta Sullivan, Bridget Meehan, Heather Maxson. He interviewed all of those individuals.
That's insane to me. That right there, that he's interviewed witnesses that testify in this trial that he has any part in at all. That would be like, hey, we're short on officers, so we also had Proctor out there watching the jury. Or we also had Proctor here at the courthouse making sure the Karen Reed supporters were X amount of feet away from the courtroom. We had Buchanan out there making sure that nobody was causing a ruckus. We had, all these people, Lally out there, not Lally, Tully out there making sure nobody was talking to any of the witnesses that said they were being harassed. It's like, you just can't do stuff like that. You very clearly can't do stuff like that. So I don't really care how short-staffed they were. It's just, and I talk about this on different boards that I'm on, right? I find myself sitting on boards now, and I'm in that period of my life. It's like, I'm not calling you a bad person by saying there's a potential conflict or there's the appearance of impropriety. So let's just avoid it. I do it to myself. There are judges that we recuse ourselves from because we're very good friends or deacons at a church together or whatever it may be. People don't like to say, I'm going to recuse myself. But this is a situation where Fanning should not have had any kind of position to do with this case in this trial unless it was testifying against Karen Reed about some of the interviews he did with the witnesses.
Or took part in those interviews. Lieutenant Fanning was at the defendant's home and seized her cell phone in January of 2024, just months before the trial began. Lieutenant Fanning was included on the text chain where Trooper Proctor said he was going through my client's phone looking for nudes. And then his name comes up at sidebar as the commander of the extensive security operations attendant to this case, and he's the source to whom something was reported about juror misconduct. When you couple those two things together, that he's the commander of security and a person who supposedly, through hearsay, overheard a juror making statements about the case, and they have an entire myriad of individuals to whom they could report it. They report it to Fanning, and then Fanning reports it to the court officer who reports it to the court. It is not unreasonable to conclude that he was at least within the orbit of the security operations governing the jurors, which is exactly why we put it in our papers. And without additional information clarifying that, we have no way of knowing that he wasn't involved or didn't have any direct access to the jurors. If he didn't, he didn't. And that's a fact that everybody can agree on. But when we heard the information, the only reasonable conclusion we had, given the fact that he was the source of the information and he was defined as the commander of security over the entire case, not part of the case, the entire case, which includes the jury, that is a reasonable conclusion.
So you signed your affidavit 2 weeks ago when you already knew that he did not have any access to the jurors.
No, I didn't. I absolutely did
Signed
not.
and sworn under the pains and penalties of perjury this 21st day of February 2025.
Correct. On February 21st, 2025, we were still at the first time that it was mentioned that he had absolutely no access to the jurors. He never had any contact with the jurors. When we received our responsive documents from the opposition from the Commonwealth. In that document, they mentioned he never had any direct access. He didn't have indirect access. They make these claims with no verification, by the way, no declaration, no supporting evidence, no declaration from the attorneys who filed the opposition.
And there's going to be more issues with that, where they're not filing their declarations. They're not giving us the evidence ahead of time. They're not telling us what's going to happen in these hearings, and we're showing up and having to respond to things. And again, that's just not how it's supposed to be done. Johanna said, if Brennan thinks it was a mess because of the investigation/case, couldn't he dismiss the charges? I think he would need some approval from the higher ups, but he could definitely push for it. Chris K, would withholding inculpatory statements or physical evidence still be a violation? Absolutely not, Chris. Great question. No, it has to be exculpatory. It could be a discovery violation, yes, but it wouldn't be a Brady violation. How do AJ and DY keep their cool in this insanity? You have to. It does nobody good, especially your client, if you fly off the handle and the judge hates you and you give her an excuse to throw you off the case or sanction you. You're not helping your client that way. Christy said, maybe it's just me, but I did feel like she started to become more amenable toward the defense as the day went on. There are definitely some things she seems to agree with. I wouldn't call it amenable to the defense or amenable, as some people say. But we'll discuss some of those parts. I think that you were starting to feel that. Fanning was the lead detective in Sandra Birchmore case. I heard that was initially he was. I don't know. I don't want to read too much into it or, say whether he's a good guy or a bad guy. Because again, we don't need to get there. He shouldn't have been involved working on this case at all, period. And if he wasn't, we wouldn't have this issue. If this was John Smith, random Boston cop, we wouldn't be having this problem.
That's the first time someone actually took the position that he had absolutely no access to any of the jurors, direct or indirect. So when we filed our papers, the information that I just told the court is the information we were working from.
I will let you move on. I can tell you, I'm really not satisfied with your answer, Mr. Jackson.
Your Honor,
Well, put it this way. Let's say it this way. So now that you know that he had absolutely no access to the jury, what's the nature of the conflict? How is your client's right to a fair trial jeopardized? Now that you know it's not true.
Is there evidence? My question to the court is there evidence that he had absolutely no access, either direct or indirect, with any of the jurors? I don't know that to be true. I mean, I take the court at its word, obviously, clearly.
So we will move on from that, Mr. Jackson. We'll move on from that. So,
well, the court's asking what is our evidence of, or what's our indication of the impropriety of him being the person that actually reported this misconduct and ultimately leading to the exclusion.
This was the judge trying to strong arm him out of the argument of juror misconduct. And he's saying, I would like some record evidence because the judge telling me something. Are you taking judicial notice of this fact, Judge? That's probably what I would have asked. Again, I'm Monday morning quarterbacking, but at the time he would have said, are you taking judicial notice of that fact, Judge, right now and putting it on the record? Because if you do, okay, then we'll have to abandon that. But if she's wrong and they find out later somehow, which again, then you create a burden for the defense to uncover things that seem impossible to uncover, that they wouldn't have found out if not for some good Samaritans and people speaking out. And yet that's the position she's putting him in, which is not a position a judge should put a lawyer in. Tracy, another 20 memberships. Thank you so much.
Of a very, very defense-friendly defense-friendly juror, or presumably a defense-friendly juror, and knowing at the same time that he was intimately involved in the prosecution of my client, that's the reason. Because he was at least within the orbit of commanding, according to Ms. McLaughlin, commanding the extensive security services over this case, and he ends up, just ironically, who knew? He ends up being the source of the information that got that juror removed. That's awfully coincidental, Your Honor. And yes, that's the foundation on which we built our argument that that shouldn't have happened. He certainly never, ever should have had any access, even in the orbit of the jurors, directly or indirectly, and the court never even inquired as to why he was the one receiving the reports. Why Lieutenant Fanning, of all people, who then reports it to the court officer, who then reports it to the court, who then removes the juror? That's an awfully straight line between Lieutenant Fanning, who has an interest in this case, and the removal of a juror. That's improper, in our view. And that's why we put it in the papers, and that's why we argued it the way we did. Because we were working off of extremely reasonable beliefs based on information that was provided to us at sidebar in the court's presence.
all right. So that's your answer to my question.
That's my answer.
May I have a moment to confer with counsel?
Yes.
He knows this not to be true. For that, the court invoked Mr. Yanetti and said, as local counsel, he knows this not to be true. Mr. Yanetti just indicated to me that that's not quite the fact. And so Mr. Yanetti, I think, should be able to at least address the court. As the court said yesterday, when we file something, we file it on behalf of everyone, including Mr. Yanetti. So if the court would allow Mr. Yanetti to explain what his experience is, that may elucidate on this issue.
If we have time later, go on with your argument.
So it was this really big deal that she tried to press. And then right when they wanted to respond, they said no. So now he's finally going to get into the actual misconduct that he filed this motion to dismiss for. But before we get to that, let's take a little break here and run an ad I'm really excited about. If you guys have ever tried this product, let me know. I'm really excited to tell you guys about today's sponsor, Dream. It's not falling asleep that was ever a problem for me, but staying asleep was a struggle. I'd either wake up in the middle of the night or way too early in the morning, and I couldn't shut it off to fall back asleep. But since I started using Dream a few months ago, and I wanted to test it out and see how it actually worked for me before promoting it on my channel or partnering with them at all, it has helped a ton. And I used to take stuff once in a while, some of the other brands out there that, sometimes are for when you're sick, but I would always wake up feeling hungover. And that grogginess is gone with Dream. I don't ever feel it. Dream is a revolutionary approach to sleep with natural sleep supportive ingredients in the form of guilt-free, indulgent hot chocolate. There's no added sugars, only 15 calories, gluten-free, dairy-free, vegan, non-GMO, keto-friendly. And sometimes if I just forget or don't have time or have a huge dinner before bed, which is not recommended, I love to keep these Dream capsules right next to my bed. They're the powder that you mix in, but just in capsule form, and I love it. Quick, easy, great night's sleep. So get the sleep you deserve with over 35% off Dream. Just click shopbeam.com/Peter Tragos, which is in the description, and use code LYK at checkout. Make sure you use the code so they know where you found and heard about Beam. All right. So now we get into, and we can talk about it later on in the video if you guys have any questions about Dream, because I do actually love it. But let's get into the actual misconduct that is a part of this motion dismiss. And Ashley asked this question, the most egregious thing you heard today, wild day. There were just way too many to pick one, way too many, but we will definitely highlight the top few, I will say. All right. And then we're going to throw up Tracy just continuing to drop memberships on everybody. So thank you so much, Tracy. That's awesome. All right, here we go. So Jackson focuses on the Sally Port videos, which I think is smart. I think that's the most egregious problem. I think that's their best argument. I think that makes the most logical sense, that you can't just say, oh, this was an accident or it didn't happen or whatever it may be. The judge, they start talking about Sergeant D, which I'm just going to call him D. Everybody kind of messed up his name today. Brennan, the judge asked Brennan, is Sergeant D available for to come and testify? Is he available? And Brennan is like, he's not available today, but he would be available if we needed it. And that's an indication for us to think about, is Judge Cannoni considering an evidentiary hearing? Questions like that make me think she may be. And do we think we need Sergeant D to come and sit here and be asked questions? Well, Jackson says, again, and this is going to be a big part of it. I don't know how to attack this specifically for what the standard is. We'll get to that in a second. The taillight vehicle and the pictures and when they were taking, and all of that is such a huge part of the case. The defense says that's so important to us, and that's why this is prejudicial, because this video would have shown that the taillight was cracked and not destroyed, basically. And all the pictures that they have are of the next day. They didn't take pictures beforehand. Hank Brennan agrees that is absolutely not how it is supposed to be. So anybody who's arguing that, oh, that's no big deal or whatever, it's like, no, Hank Brennan agrees this is absolutely not how it's supposed to go. He doesn't agree with everything, but he at least agrees with that. He goes through how some of the videos have trickled out. He says the Commonwealth knew that these extra videos existed during the first trial and withheld it. Buchanan said he watched video with Lally on the stand, didn't remember which ones, but there was all this mention of video throughout the first trial. So it was very clear that law enforcement knew, therefore the Commonwealth knew. And before we get to the first clip about what Proctor may have known, let's talk for a second about presumed prejudice versus proving actual prejudice. And depending on what that standard means, that is the number one question we're talking about. Is it exculpatory? Meaning, is it good for the defense? Does it have a reasonable probability of affecting the outcome in a positive way for the defense? And the defense says this prejudice should be presumed based on the case law they cite. The Commonwealth argues the defense has to prove actual prejudice, which they haven't proven. So actual prejudice means, again, it hurt the defense's case, and it would have helped the defense's case if it would have come in, therefore it's exculpatory. But presumed prejudice, if Cannoni believes that that's the standard here, that means that the Commonwealth has to come and prove and argue why this actually didn't cause prejudice. So it's like burden shifting. If you have to prove actual prejudice, that's on the defense. If it's presumed prejudice, it switches to the Commonwealth to prove this actually didn't hurt the defense at all, which the Commonwealth does make those arguments. And we'll break down what are the strongest arguments, but that is really the question before Judge Cannoni. Now, floating at the top of our head, which I'm definitely going to focus on and talk about as well, is the interest of justice. We can't forget that. How does that affect this, regardless of what the judge's decision is in this case? Let's take a listen now to the first clip of Jackson's argument we are going to hear. If it ever starts.
Or exterior video, and did not provide it to us intentionally. Either way, the withholding that evidence admitted to now by Buchanan was obviously egregious. It was obviously in error. It was obviously calculated. Another important material fact not in dispute. On April 10th, 2024, the DA certified disclosure of, quote, all evidence.
Sorry, can I just get back to that, what you were just discussing about May 2023?
Yes.
How is that exculpatory?
Because the videos themselves, as the court will see through the presentation of my oral argument, the fact that those...
That is the ultimate question, right? Why and how is it exculpatory? How is it hurting the defense that they were not given this evidence? And just by asking that question, I get the feeling Judge Cannoni may also agree, she may never tell us, but she may also agree that the Commonwealth either withheld intentionally or negligently video clips from the Commonwealth. I just saw a comment say, post the link here, which John said was already done. So John, can you make sure the link is posted in the description, because it needs to be there. Sorry. So it feels to me like Judge Cannoni does agree that the Commonwealth withheld these videos from the defense, but she's asking the ultimate question that if it's not exculpatory, then this case is not going to get dismissed. Period. The end.
Videos all just happen to either be grainy, wobbly, missing 42 minutes, or from the wrong angle and flipped backward. All tend to show that the Commonwealth doesn't want the condition of the taillight to be seen by anybody when it's pulled into the salad bar. That is a reasonable inference. In other words, it's the cumulative effect of the bad videos that helps us. That's why it's exculpatory.
All right. And also, could you explain to me the prejudice?
I will get to the prejudice as I move through.
Now or no?
That's what we need to know. Now, she wants to short circuit his argument. He doesn't want that. Okay. Obviously, he doesn't want that. He wants to make his argument in full, which I get it. He has the right to do that. But she's getting to what she needs to know. And if he can convince her that this is exculpatory and materially prejudicial, that's how he wins. And that's how he gets this case dismissed. But just like Alessi did before, he wants to do it methodically. He doesn't want to just jump around and it be this scattered, unorganized argument. So I get why he says, I will answer it in time, Judge. Watch this earlier. What happens if Bev doesn't dismiss or grant a hearing? I feel like a hearing is a must at this point. She's got to make findings of fact as to why this is not exculpatory or materially prejudicial to the defense, and just say it's not, so we're going to continue on. Does this exclude Brennan from working in Norfolk County as a defense attorney from here on out? Quid pro quo? No. But it is interesting. There's got to be some issue or wall that they build that he can't cross. I don't know the answer to this, how they do it in every jurisdiction, right? I don't know the answer to this fully. It's a great question. I'm pretty sure Mike and Odie said, I'm pretty sure Andrew Burkhart looked it up and said Massachusetts is a different standard and doesn't have to prove exculpatory for Brady. I don't think that's right. I trust Andrea's research. I trust Andrea's research 100%. I cannot believe that there's a state that you don't have to prove it's exculpatory. That doesn't make logical sense to me. It doesn't line up with what Brady says. So I don't know. We'll put a pin in that one. Tracy said, Melanie Little sent all cupcakes here to share some love. Well, thank you, Tracy. Thank you, Melanie, for that. That's awesome. Nicole said, if there's a hearing, do you think Proctor can plead the fifth? Could. I mean, if he thinks that it's potentially incriminating some of the statements he's going to make. Peter, can you do a video on R.A. Brady material? Ricky Davis mailed 8 letters about Logan confession to McClelland, all withheld from the defense. Baldwin on fire. I'll have to look into that. I haven't gotten sent that really by anybody. So if people are interested, let me know and I'll try to take a look at it. I try to do as much as I possibly can for the most people that are asking for it to hit the most things. Mike and Odie. Andrea looked it up and said they don't have to prove exculpatory or prejudice in Massachusetts. That just doesn't make, then why would they dismiss the case? Just because something was withheld, like if I withheld a screwdriver that I found at the crime scene and then gave it to you case number 2, you wouldn't get the charges dismissed because there was a screwdriver at the crime scene that wasn't prejudicial and wasn't exculpatory. So that doesn't make sense to me. I don't know everything about Massachusetts law, so I'll just tell you, I don't know why Jackson wouldn't just say that then. Why, when she asked about exculpatory and prejudice, did Jackson not say, Judge, in Massachusetts, it doesn't have to be exculpatory, it doesn't have to be prejudicial? I don't think that that's correct. I don't know. I'm not accusing anybody of everything, but I don't think that's correct. Eric said, my wife, Kay, loves the lawyer you know, free Karen Reed. Well, hello, Kay. This is like the Rust case. No, we're gonna do some comparisons later. We are going to do some comparisons later. Don't you worry.
If you're going to do it later, that's fine.
I will do it later. I think the prejudice is cumulative. Obviously, we didn't have the information that we needed to be able to cross-examine the witnesses that we needed to be able to cross-examine at the time that it was provided. It just very obviously. There were certain videos that were clear from some cameras on other days and other times, but these cameras that were late discovery that was provided to us just so happened to all go out. They all find their way to be defective in one way or another at the exact moment that we would need them. On April 10th, 2024, the DA filed its certification of giving us all evidence that they had in their possession and that they had done a reasonable inquiry. Both of these, that certification is just flat not true. How could that be true? And we're still getting video evidence that is in their possession, custody, and control in October, in January. How could that possibly be true? It isn't true. And it's illuminating when you look closely at the Commonwealth's opposition to our motion.
We said the same thing. It's like, it doesn't make, why would you, it sounds like, and sometimes lawyers just do this. If judges are not going to hold lawyers accountable, you serve the certificate when discovery closes. It's like, we did our best, judge. But if more exculpatory evidence comes out, the judge is going to let you enter it because, and the judge also agreed with Jackson that removing this evidence as a remedy doesn't work for the defense. She's like, I get it. Because this evidence is, you say this evidence is good for you. So I get that. And Brent, they can watch anything on YouTube. They can look at stuff on Twitter. They can see what the people, we collectively, all the chats and everything around the world are saying. If they want that information, they can get it. They know where to get it.
First and notably, the Commonwealth makes these broad statements couched as fact. They're bold pronouncements. And there's myriad excuses in their opposition paperwork. And it's backed up by next to nothing. Not a single exhibit at the time they filed their opposition. There's some exhibits that have been lately provided, including some exhibits just a few minutes ago that they're now adding to their exhibit list and to their opposition. But in point of fact, at the time they filed their opposition, there was no factual support for any of its positions.
So are you pointing me to something specific, or are you just saying in general and you'll wrap it up?
In general, the only thing that they had attendant to their opposition was this joint affidavit that doesn't address any of the defense allegations at all. Contrast that with the defense motion, which was supported by nearly 20 fact exhibits. There may be a reason why they didn't support their positions with exhibits at the time, because the facts don't support the Commonwealth's position. These are indefensible and indisputable facts that I'm explaining to the court about the turning over of these Sallyport videos. Specifically turning to the Canton PD surveillance video. The opposition says, or reads, the Commonwealth provided the defense with
I just always like to read along. Where does it say it?
I don't have the page number.
Okay.
It's the point at which the Commonwealth indicates that they provided 90 photographs,
Okay.
Crime scene photographs in support of the vehicle in the Sallyport. That is a distraction. What they don't mention in their moving papers is that the date of those photos were all February 1st, 2022. There are no photographs from January 29th, 2022, when the vehicle was brought into the Sallyport. The only thing we would have would be the videos, the surveillance videos, all of which are somehow, some way defective, and which were held in their possession in some instances for nearly 3 years before it was turned over to us. So it's the condition of the car at the time that it was brought into the Sallyport on January 29th at around 5:30 p.m. that matters. That's the only time that it matters. The other evidence referenced by the Commonwealth about a 5 a.m. ring video and Canton Police Cruiser at 8 a.m. and the independent observations of Dighton Police Officer Sergeant Barrows, they all corroborate the defendant's contention that the taillight was cracked and not shattered at the time it was brought in to the Sallyport.
And so this starts to get into the argument that the defense makes that one of the biggest problems and prejudicial effects and the fact that they didn't have this exculpatory evidence is that the taillight was cracked and then later smashed. And he quotes the Commonwealth saying the defense struggles to show how it's exculpatory. He's like, no, this is easy. Well, he's right. The defense is right. If it was cracked and shown as cracked on these videos and then later shown as smashed, that would be exculpatory. But does it show that? Do they show that? And that's kind of my rub, where Judge Cannoni does have an out here. She has an out if she wants it, and I think we all know she's going to want an out. Thank you, Rebecca, for gifting memberships. So the videos are so blurry and grainy and skippy and all this stuff that they're so bad that, shocker, the benefit, or the Commonwealth is getting the benefit of the poor quality of these videos. Because the quality is so poor, and we can say they're edited, but because of the way that they were saved, they have destroyed any evidence that they were edited. Therefore, the defense doesn't actually have the exculpatory information, in my opinion, that they say that they have. What they mean is, if the videos were true and correct, this is what we know that they would show because we know what the facts are in this case. That's what they mean. We know what's on that video, Judge, because we know the facts and the truth in this case, but the videos don't clearly show that. And the way I know that they don't clearly show that is both sides will show you the same picture of a taillight, which we're going to talk later about Brennans showing us the taillight. And both sides are going to tell you it shows exactly what they say it shows. Brennan's going to say it's all busted up and exactly the way the Commonwealth needs it to be with the big shattered taillight. And the defense, it's going to say a little crack with one piece missing. It's not clear. I know what I think it shows. I definitely think it shows more along the lines of what the defense says than what the Commonwealth says, based on the 50 pieces or whatever they had to put together to recreate it, where there was still a little chunk missing. But I could understand if reasonable minds could differ on that. And if jurors could differ, that is a jury question. So because that is a jury question, does that show exculpatory evidence that materially prejudiced Karen Reed to not have. And I knew everybody's going to say, oh, it's clear. I get it. If you think it's clear, that's fine. I think it's just muddy enough for Judge Cannoni to say, not exculpatory, not prejudicial. It's giving her an out because of what the defense is specifically saying is exculpatory. Now, the best argument with all of this is still, like I've been pushing from the jump, not the jump, recently I'll say, not the jump, definitely not the jump, is all of this, even the admitted horrible investigation and prosecution of this case that Brennan's going to say when he argues, adds more to this case should be gone in the interests of justice. That's what this was really highlighting almost more than anything else, because legal technicalities to get a case dismissed at this point is very difficult. And people ask, what is the difference between this and the Rust case? The evidence withheld is very similar, in my opinion. Something that could be good for the defense, could impeach some of the prosecution witnesses. The defense would definitely have asked questions about it. But were either of them a smoking gun? Were either of them rock hard, solid proof of the defendant's innocence? No. Doesn't need to be that to be exculpatory and prejudicial. The way that they were put into wrong files and stuff even was very similar between this and Rust. But the difference between the Rust case and the Karen Reed case is the judge. And that's why it was so shocking in Rust that she actually did it. Because there aren't that many judges that would make that call in such a high-profile trial. That's the difference. As I see it as a lawyer, that's the biggest difference. Of course, jurisdictionally, there's a difference. But I really think the judge is the difference, because there's a lot of judicial discretion when we're asking the questions we're asking here, which people aren't going to like, but that is what it is. And she has to abuse that discretion for this to get overturned on appeal later. He talks about how the Commonwealth said it came close to the traverse, but they showed everybody it jostled that 5,000-pound traverse. Later, Brennan says that the ARCA witnesses say at that rate of speed, it wouldn't cause the damage to the taillight that the defense said it would cause. He says that the information is exculpatory because it impeaches their lead investigator. I think that's a great argument. I think that's a better argument than it would show a cracked taillight. Because I don't think the judge is going to go for it will show a cracked taillight. But could it impeach Proctor? Well, we're going to hear more about the difficulty of impeaching Proctor. Sleuthy, yes. Abuse of discretion is not an easy thing to prove to overturn a judge's decision on a discretionary call. But to me, the way this was all explained today, there's no doubt that at least some of these Sally Port clips were intentionally withheld from the defense. Did Proctor intentionally withhold them? Did the prosecutors intentionally withhold them? Did Buchanan intentionally withhold them? It doesn't matter. Jackson said, Proctor is the prosecution as the prosecution is Proctor. So it doesn't matter who intentionally withheld them. I believe it was proven by the defense and admitted by the Commonwealth today it was intentionally withheld from the defense. Doesn't mean it's going to get dismissed under this motion, but I feel confidently saying it was intentionally withheld, which is par for the course in this case. All right, let's listen to another clip.
The case and either regularly report to the prosecutor's office or have done so in this case. Michael Proctor worked out of the Norfolk DA's office, physical plant. There is no question that Michael Proctor and both agencies intentionally withheld that evidence. Let's talk about Michael Proctor's testimony before that grand jury. He was asked the following question. Are you aware whether there are any cameras in the garage or Sally Port where Karen Reed's SUV was parked? Answer, yes. Question, have you reviewed the footage of that garage? Answer, I saw one very grainy video and then another of Sergeant Buchanan and I arriving in the main entrance around 5:30 following the vehicle. Question, when did you watch the video from the Sally Port? Answer, I haven't reviewed it, sir, in quite some time.
So do you have those page numbers for me?
I can get.
Which means he reviewed it a while back, which means it exists. And he knows it exists, which means the prosecution knows it exists, which means it should all be given to the defense at that point. Actually, even before that point, it should have all been given to the defense.
Get them for you, Your Honor. I didn't cite them in my notes.
Yeah, if Ms. Little can get them for you before you finish, that would be helpful for my review.
I haven't reviewed it, sir, in quite some time, so I can't recall what's on there. Question: why did you review video of the Sally Port? Answer: we review every video we pull. We pull a lot of video. It's on the case officer to watch it. By his own admission, Your Honor, Michael Proctor recognized himself in a video along with Sergeant Bupnick. That was likely the video that ended up being inverted by where Michael Proctor was by the passenger side taillight. And that was before any taillight material was ever recovered at 34 Fairview. That is highly inculpatory of Michael Proctor. It is highly exculpatory of Karen Reed. Another point of fact: by his statement, Michael Proctor admitted that, quote, we pulled, end quote, the video. That video is on a 30-day overwrite. The Michael Proctor testimony in front of the federal grand jury is at page 79, lines 1 through 13.
Thank you. Thank you, Ms. Little.
Exhibit C, is it Charlie?
Okay.
The video is on a 30-day overwrite, Your Honor. We all now know that. We didn't know that before just a few weeks ago. I don't expect that the Commonwealth knew that either. This is new to everybody, right? But you have to pull the video within the first 30 days to even be able to review it. We've been getting these videos in dribs and drabs for not months, but for years. Actually, it's been months. Hasn't been years. He further admitted that it shows the SUV arriving in the Sally Port at 5:30, which means he wrote those reports and signed those affidavits, the 9 that I was talking about earlier, with full knowledge that there existed a video that he had and had reviewed that proved he was lying. It doesn't get any more exculpatory than that. And that was the video. That was the very video that was withheld from us, from the defense, for 2.5 years until the middle of trial. The Commonwealth says the, quote, trial prosecutor, end quote, was not aware. It's becoming a...
I like how he kind of makes fun of the trial prosecutor. Why don't you just throw a name out there? You've already thrown Lally under the bus enough. Do you mean Lally? Why don't you just say it? Emily thinks all the Commonwealth witnesses want this to go away, maybe including Lally. I get it. So again, that makes a ton of sense what he's saying, that this had to be pulled within the first 30 days or none of it would exist. That's at least what they're telling us now. So when you get this, you get caught up in things that you say, like, is that actually true? I don't know. But now that they've said it and they've used it as an excuse as to why we can't still download it, well, now it's got to apply to the other stuff, to the other things you say. The only video that was clear was the inverted video, and the only camera that was replaced was that one because it was defective. Isn't that funny? He keeps using the Commonwealth verbiage like, you know, this would have been nice to know, et cetera, et cetera. Graz said, I wish he would have used grave concern at some point. Yeah, it did feel like it was going there, right? It definitely felt like it was going there to me. Then we took a lunch break. We come back. He says, again, the Commonwealth says they don't have the video, but it doesn't matter. It's in their control and it prejudiced the defense. Possession, custody, or control, right? That was a theme of the hearing, and that is so true when it comes to law enforcement and the Commonwealth. If one has it, they both have it. Vicky, did you get to watch the video of Morrissey categorically declaring Karen Reed guilty? Somebody else asked me about the Morrissey hostage video after this clown circus. Of course, pretty pleased with Sugar on top. Well, you're going to have to wait for the Morrissey video, but not too long. I'm going to go ahead and break that down and look into the specific Massachusetts rule for what prosecutors can and can't say publicly, break it down and compare it to that video for Monday's podcast. So you're going to have to wait to hear my thoughts on that one. And oh boy, I was pretty surprised when you guys sent me that was actually a real thing. If it was AI, you guys got me, and I'd believe it if you said it was AI. Jinx. Will this trigger the Supreme Judicial Court to examine all cases Canoni has presided over for prejudice and collusion? No. No, it will not. If the defense theory is evidence tampering, isn't it arguable that any CPD Brady is inherently exculpatory in that it could be argued that way to a jury? So yes and no. That's not really their full theory, but it is part of their theory. And that's why it is part of the exculpatory nature and what they can use. The judge just has to determine, does it get to that line and threshold of being material enough? This goes along with kind of Kate's question. Isn't the issue just that they withheld it? No, because if you withhold something that's not material, or if you withhold something that's not exculpatory, the repercussions and the remedies and the sanctions are not the same. There still can be sanctions for discovery violations, but it's not the same. Chelsea B said the Commonwealth claims it's the weapon. How would it be exculpatory? Well, if they withheld the car, right? If they withheld the Lexus, then maybe, but it's a video that they ended up turning over later that was too blurry to really prove anything and had too many snippets and was inverted and all these problems that I would say the Commonwealth created, but that's also the argument they're using. They're getting the benefit of their misconduct. That's what it feels like, right? That's what it feels like to me. But in the judge's hands, if she's not going to find that there was misconduct in editing, then how much do these videos actually prove? That's a question for the jury, right? If the jury looks at them and says, oh, wow, that is exculpatory, well, then they are. But if they look at them and say, I can't make it out, then they're not. How did the Commonwealth show videos from before Karen Reed inverted the video? I thought they were gone for 30 days. Janet. You're trying to do what Judge Cannoni did. You're trying to do to me what Judge Cannoni was trying to do to Jackson, to rush it, get it out of order. I'm just kidding, of course. We will get to this, I promise, when we get to that portion of Brennan's comments. All right, let's listen to another section of Jackson where he says, are you going to hold us to the same standards here, Judge?
That the individuals on that inverted video were himself and Michael Proctor. And they made the point that Michael Proctor never approached or had any access to or didn't manipulate in some way, shape, form, or fashion. This would be intimation by the Commonwealth, that passenger taillight. The Commonwealth has now conceded that that person was, in fact, Michael Proctor. It's notable that the Commonwealth went to great lengths to state that, quote, Trooper Proctor, and this is in their opposition, Trooper Proctor is standing feet away from the defendant's vehicle and never touched the right rear taillight, end quote. That's a statement made in their moving papers, specifically on a fact that is of great material importance to this case. The three prosecutors signed an oath and a declaration, and the court just called the defense out on signing a declaration or an oath. And the court's intimation, at least in its initial comments to me, was, you may have said something that you don't have a factual foundation for. I think I have done my best to disabuse the court of that we were drawing from reasonable inferences. I wonder if the Commonwealth is going to get the same treatment for saying that Trooper Proctor was standing feet away from the defendant's vehicle and never touched the right rear taillight. That's a very bold statement for the Commonwealth to make, and it's also completely untrue. It's not supported by a single fact. It's not supported by a fact or evidence before the court. The problem with this unsupported motion, because it's unsupported and the declaration is signed by three different individuals, you can just sort of say whatever you want in the motion. And I guess get away with it. The video speaks for itself, Your Honor. It shows Michael Proctor walk behind the car directly to the position of the passenger taillight. He positions himself right on the other side of the camera view, not feet away. And it certainly does not show, and there's no evidence before the court that he, quote, never touched it. As a matter of fact, we would submit.
Does it show that he does touch it?
Well, of course it doesn't show he touches it, Your Honor. It's like he's on the other side of the car.
That's kind of the point, right? That's the point of where I think the judge's mind is going. And that's kind of an indication of it, where she's like, okay, so let's say it doesn't, let's go with your thinking. Let's say it doesn't say what the Commonwealth says. It doesn't show that Proctor's never by the taillight. Let's say it does show that he's by the taillight, but it doesn't show he busted the taillight. And their argument is it doesn't matter. They're making all these arguments that it was impossible for this to happen. He was never alone with the taillight. He was never near it. He never had the opportunity to. And that's not true. So we're impeaching Commonwealth witnesses. But you see the way Judge Cannoni's looking at it, where these videos don't prove Karen Reed's innocence. And unfortunately, judges so often in motions to dismiss for very serious crimes will instead change the burden from what it should be. Cam said, I thought Brady and Napule state any evidence a reasonable jurist could debate as to helping the defense, not change the result, just help. It's definitely not change the result. It's not like the appellate standard, but it is something that actually has a reasonable probability of affecting the outcome, which I guess some jurisdictions might argue it is a reasonable, it's reasonable to affect a juror or to make a juror side with the defendant. I think that's saying it the same way. Risking abuse of discretion rather than holding a hearing seems nonsensical. I've got thoughts on whether or not I think there should and will be a hearing here. But you can tell how Judge Cannoni is looking at this standard based on her questions.
The point is a reasonable inference is he could have touched it. He was standing right there. Nobody forced him. Nobody was holding a gun to his head. He walked around the other side of the car and obviously was standing there for a reason. By himself, in a corner, out of the view of the camera. And then when the Commonwealth plays the video, it switched. And the intimation to the triers of fact was he never approached the right rear taillight, that passenger taillight. And all of that.
And you cleared that up.
Right. But that is the galling part of this entire thing. The court has asked me a couple of times, and I'm going to get to a little bit more in detail what the prejudice is. If that's not prejudice, I don't know what is. It's literally propounding false information to a trier of fact. That is not a small thing. Even after the trial was over.
All right. I think that was the end of that clip. Yes. They're still getting, okay, he says they're still getting evidence or videos, and they still don't know the source. They enter Sergeant D's report in. They talk about how the chief of police wrote LOL. That's how it records, no tampering. And, everybody makes a big deal about that. It's just a joke. And it goes to what this investigation was and how, it's looked at over there. But even after Brennan goes through his timeline of misconduct, basically, which we're going to get to, I still have so many questions about how this is possible. Like, if you downloaded some of the clips and not others, how is that possible? Was there anybody that ever actually downloaded the whole thing and clipped it up? Was there a program that did it? There's so many unanswered questions that I just don't see how the judge, if she's going to dismiss this case or not, I guess if she's going to dismiss it, she could dismiss it. If she's not, I don't understand how you don't at least have an evidentiary hearing to let the defense ask these questions to try and figure out how this is actually possible. But if you think it's not exculpatory and it's not prejudicial, and you even take the defense at their argument that the Commonwealth did this intentionally and they withheld this evidence, but it doesn't matter because it's not prejudicial, it's not exculpatory to whatever Judge Cannoni's standards are, and you just dismiss the case. Meg said there was a point made during EDB's live regarding an evidentiary hearing being a way out for Judge Cannoni. Can you tell us a bit about how an evidentiary hearing works and why the outcome of it would differ from dismissal? I don't know that the outcome would differ from dismissal, but the way an evidentiary hearing would work is you call Proctor, you ask him what he knew and when. You call Sergeant D, you ask him what he knew and when. You call Buchanan, you ask him what he knew and when. You ask Lally maybe, what did you know and when? How did it happen like this? I don't understand how it happened like this. I would love to see an evidentiary hearing on this. All right, let's jump ahead a little more. It's definitely going over an hour tonight, so everybody hit that like button. We're almost at an hour already.
June of 2023, according to DG Petro, he downloaded every single bit of video of that car while in the Sally Port or while at Canton PD in Sally Port. How is that possible? How could that be? As of February 28th or maybe March 1st, those videos are gone. So how could he have access to the whole thing? It's because someone at the Commonwealth downloaded the whole thing. They saved it. Or the only other explanation is that DVR was not at the time on a 30-day override. It's the only two explanations. Again, this is binary.
And M. Grace, that's kind of my point. This is the point of the Commonwealth benefiting from their potential misconduct. It's not exculpatory, Judge. Tell them to prove it's exculpatory. They can't even really show what's on the video. But from the judge's point of view, if she's not going to say presumed prejudicial, or she believes the Commonwealth proved it wasn't prejudicial, then that's where we are.
So in April of 2024, as the court knows, we got additional video, and that's the inverted video. In the spring of 2024, while trial was being held, DG Petro, quote, it says, quote, I downloaded some video recordings that you and I believed may be needed to refute claims being made by the defense. The you and I is him to Chief Rafferty. That's who this report is to. And it includes footage of Higgins. So now we find out for the first time that Chief Rafferty and this sergeant had been talking and strategizing about how to defeat some defense arguments, presumably, by use of videos that had never been turned over. And the Commonwealth uses a phrase in its moving papers, I believe in this motion, about ambush. That is the definition of an ambush. So DG Petro admits that he, Rafferty, and the Canton Police Department had Sally Port video that was material to the case. Remember, his quote was that you and I believed may be needed to refute claims made by the defense. They were strategizing about how to defeat certain of our arguments, and they didn't turn it over. Specifically, he downloaded video and presumably gave it to Chief Rafferty. But then the interesting thing is...
And this is really how it feels intentional. I don't know how it's not intentional.
Chief Rafferty held on to it. She never turned it over. Probably because they didn't help the prosecution. They showed Higgins engaged in conduct that is, at the very least, highly suspicious and clearly exculpatory because it impeaches his other testimony. It shows him on the phone. And he testified that he didn't make calls in the middle of the night. There's no question that with this example, that is an intentional withholding of evidence. That is the legal definition of bad faith, and it's unconscionable to do that. Now put in context what we eventually did receive during the trial and then after. We received the inverted video that was falsely presented as the right passenger side of the vehicle. on the passenger rear side of the vehicle. Number two, we received several videos of Brian Higgins at Canton Police Department, clearly using his phone at approximately 1:35 or so a.m. And we received exterior footage that would ordinarily show the condition of the passenger taillight, which all happens to be corrupted, like every other video of the rear passenger side of that SUV. This is stunning. It's not like the Canton Police Department and the Massachusetts State Police were sort of blissfully incompetent or blissfully ignorant and unaware of the existence of these exculpatory videos. It's quite the opposite. Multiple officers, Proctor, Rafferty, Buchnick, O'Rourke, DJ, and Petro, these individuals, we believe, O'Rourke may not have known, but we know that the others did, and have now basically admitted it or been caught trying to hide it. They were all variously actively engaged with these videos. They were searched for, they were discussed, they downloaded them, they saved them, they copied them, they labeled them, they transported them, they reviewed them, and they strategized about them. These videos were top of mind for all of these folks. We know there were hours and hours and hours of footage that was so large it had to be broken down into 6-hour blocks. All of that was pulled. And none of this footage was disclosed to the defense before April of 2024. And most of the files that have been turned over so far have been turned over after the trial was over. We have no idea this footage existed. And to this day, it continues to be, the bulk of it continues to be withheld from the defense. And then we move.
Yeah, I mean, it's really, really crazy. Rebecca said, remind me, were there pictures taken of the vehicle before it was moved? Seems like no. He's saying the only videos or the only pictures that were taken were February 1st, I think he said. I think that's right. Dominic, this is probably a dumb question, but I am wondering to what extent these discovery violations are seen as remedied with having this come out before the new trial. Thank you for analysis. Quite a bit, Dominic, quite a bit. That now you have it and you get your chance here to use all of it. Show us how exculpatory it is, defense. So the fact that trial number 2 is coming up is a major remedy. I think this would be a very different discussion if Karen Reed was convicted and all of this new video evidence started to trickle out and they got all this new information. But because there's a second trial coming, I think the judge is going to just say, okay, here's your chance. I don't find this misconduct to be extraordinary enough to dismiss these very serious charges. That's what she could do. And let it all in now. And you could think time marches on and things happen how they're supposed to. And if she should be not guilty, then that's how the jury will come down. Which, of course, we know it's an uphill battle for every criminal defendant in every criminal case across the country.
To Sergeant Buchnick's actual report. As I indicated, he wrote a report last Friday as well, dated the 28th. Quote, in furtherance of the John O'Keefe Canton homicide investigation, sometime in early spring of 2022, I was made aware that a request had been made by Trooper Proctor and then fulfilled by Canton PD for surveillance video as it related to the arrival and storage of the Lexus SUV belonging to Karen Reed. This was
just wild, right? I mean, is anybody surprised that Proctor is at the middle of this? That Proctor had access, control, custody, didn't tell people, used it, was discussing stuff with people. Is anybody surprised at that at all? Because I'm not. And if this second trial goes, and I was talking with somebody today about this, it's just annoying because as a defense attorney, we talked about, I think in the last video, maybe like you're trying to keep it simple, but you got to ask Proctor about this too. It's like, you had this video, didn't you, in 2022? And you didn't turn it over. You didn't tell anybody. You put it in some file, right? And Brennan has to admit it. The judge is like, which investigator's file was it in? He's like, Proctor. It's just so bad. It's so bad.
It was the spring of 2022, he knew. At Trooper Proctor's request, I proceeded to Canton Police and picked up the digital media storage containing said video and transported it to the Canton, Norfolk District Attorney's Office and turned it over to Trooper Proctor. I did not review this video at this time.
What date did he do that? The same date?
He says at this time, but it's the sometime early spring of 2022. That's the best he can do in his report. Paragraph 2, in July of 2023, so this is a little more defined, I was once again made aware by Trooper Proctor that a request had been made to Canton PD for additional video and that it was ready to be picked up. Since the Canton Police Department is conveniently located on my route of travel to work, I stopped by and picked up the CD from the front desk of the police department, which was labeled Trooper Buchnick with a yellow Post-it note. I further added Canton PD 12922, and then the case number, which is their case number 2022-112-33, to more accurately identify the item and transported it to our office, subsequently turning it over to Trooper Proctor. So there's a second CD, now in July of 2023. I did not review that video at that time. See the attached copy of the Post-it note. Final paragraph, in my
So Buchanan's involved. He's kind of the errand boy going and getting it, putting it where Proctor needs it. Proctor definitely at the center of it. And Jackson's like, I was able to confront Proctor during trial, but I couldn't impeach him the way that I should have been able to because I just didn't know everything. He controlled the video. He controlled the evidence. He hid it. He lied about it. He fooled us. It's possible the prosecutors didn't know, but it doesn't matter. It just doesn't matter. He also makes a pretty good point when he says, the Commonwealth says both sides are aggrieved. Well, they're admitting then that it's prejudicial to us, right? And if they're admitting it was prejudicial to us and that we're hurt by this and the judge agrees that it was intentionally withheld, bada bing, bada bang. Pretty good argument. He goes into the case law on dismissal a little bit and says, he couldn't cross-examine the witnesses like he wanted to. This is the part I wanted to get to most. This was the most surprising part to me. Ashley, if I was going to answer your question earlier, this is probably the most egregious part to me, and it made me cringe as Brennan went through this timeline of misconduct, basically by the Commonwealth. Let me answer a couple questions here first. Do you think Yanetti is waiting to file an affidavit for adding Betterow until they know if Bev is kicking Jackson off the case, know the sanctions? I don't know. I don't know why they're waiting. And it could very easily just be because there's so much other stuff going on and so much work. But I don't know the answer to that. Azam, Peter, dumb question. If a higher court judge watches this hearing and doesn't agree with what Judge Cannoni is doing, can they reprimand her? No, that's not how the process works. If they think she's doing something unethical or violating her rules of ethics, they could report her to the local bar or the state bar. But no, they're not going to say, I'm going to come in and overturn your decision. Brittany, is there any higher court the defense can take this to? Is there any possible punishment for Cannoni if she is found knowing of wrongdoing? Yeah. They proved she's knowingly doing things wrong. Of course, there are sanctions and remedies for that. But this is all going to be something that's part of the appeal if Karen Reed loses. Touche. Did you find the way she kept deferring to Miss Little at times to obviously double check Jackson disrespectful? I didn't. I actually kind of thought it was uplifting of Miss Little and respectful of what she does. And I think Jackson does the same thing. A lot of lawyers do that with their right-hand person that they literally can't try cases without. Like it is a relationship that's hard to describe. She said, you cleared that up though, right? With regard to the inverted video. So in her mind, that was the remedy. In my opinion, she'll say they have it now. So it's been remedied already or not material exculpatory. Yeah, I agree with you. And it's just not the same. It's just not the same. And the opportunities were not given and they didn't have all the ammunition that they could have and would have used it if they had it at the time. Unchecked Lie says they have reports stating that all video from the entire time its CPD was downloaded, it's presumably destroyed since it's still not turned over. What is the remedy for destroyed evidence? Well, it depends. If it's exculpatory and it's Brady evidence and it's prejudicial, then the case can get dismissed. If it's not, there can still be some kind of instruction given to the jury that the Commonwealth destroyed this evidence, and you can give a negative inference to that evidence. Keminoic. They had all the video. It was still available and deleted summer of 2024. I believe HB admitted that in response. I don't remember him saying they had all the video and admitted that it was deleted. I don't remember that. Okay. Let's finally get to what Hank Brennan had to say about all this alleged misconduct.
By some of this. So know that that's what I'm focused on.
I understand clearly. In November of 2024, the defense asked me to see if I could provide a chain of custody regarding the production of video in this case. And so I agreed that I would do that and made best efforts to talk to as many witnesses as I could, review the discovery, and speak to the attorneys. Now, when I started sometime in late September, I had found the letter from Chief Rafferty with the production of video in August. The letter or note was dated in August. So to start from the beginning, the prosecutors in this case did not have knowledge that there was videos from the Sallyport area. There was nothing about it that was particularly relevant to them. The defense theory did not make it clear to them that that was important. There was no motion filed by the defense.
At what point in time?
This is leading up to trial. At that point, there had been no request by the defense for video of the Sallyport area.
The defense obviously disagrees with that, with their request. But again, it didn't specifically say Sallyport video. So the Commonwealth's going to say they didn't request it. The defense is going to say they did. It is true. If a prosecutor has absolutely no reason to believe that something is important, it doesn't mean you have to turn every single thing over. Every single video of the entire Canton Police Department doesn't need to be turned over. Every single picture that's ever been taken, outside of 34 Fairview, from any time of all time doesn't need to be taken. It could become relevant later, right? If something changed, if they change the front door or whatever, then it can become relevant and potentially exculpatory later. But there has to be a reasonable belief at the time that it may be at least relevant and evidence that may become relevant to the case. I think the defense would argue very clearly this is relevant, especially because the car is the weapon used, but the Commonwealth is saying at the time we didn't believe so.
What I learned is that Trooper Proctor had requested Sallyport video from the Canton Police Department. And the person who was the custodian of Canton Police video who would download it from the DVR was Sergeant D.G.M. Petro. He made a request shortly after this event on January 29th, 2022. Sergeant D.G.M. Petro downloaded video from the front wall camera, which was later characterized as the blurry camera, and he left it at the front desk. Trooper Buchanan, at the direction of Trooper Proctor, picked up the video and he brought it to Trooper Proctor. Trooper Buchanan did not look at the video at that time. It was given to Trooper Proctor. Trooper Proctor did not provide it to the prosecutors. So Trooper Proctor was aware of the video. The prosecutors were not aware of the video. That video is the same video that Sergeant D.G.M. Petro says that he downloaded the video in 6-hour segments, and that contained the front wall, blurry camera inside the Sallyport, and camera in front of the police station. That remained with Trooper Proctor for some time. In June, around June of 2023, Trooper Proctor then made a second request from Sergeant D.G.M. Petro.
It's really interesting that the lead investigator, Trooper Proctor, can find out that all this stuff is relevant and material, and he needs to see it and he needs to know about it. But the prosecuting attorneys on the case can't figure that out. They never requested it. It was never mentioned in the trial prep or the investigation or anything that was going on behind the scenes in this case. I find that really, really hard to believe. But even without admitting that, all sorts of wrongdoing is admitted here.
No, we already had it.
For different cameras. He wanted cameras, camera angle of outside the Sallyport area. So when the tow truck dropped the car off, leading into the Sallyport, which is now characterized as the exterior Sallyport video. Again, Trooper Proctor asked Trooper Buchanan to go to the Canton Police Department and pick up a copy of the downloaded video. Trooper Buchanan went to the police department, picked up the CD at the front desk. That CD had a yellow sticky tab on it with Trooper Buchanan's name, and Trooper Buchanan wrote in the case file on that yellow sticky. He brought the CD to Trooper Proctor. Again, Trooper Proctor in June 2023 had a copy of the exterior Sallyport video, but did not provide it to the prosecutors. Both of those videos remained dormant. When Trooper Proctor was called to the federal grand jury, essentially he testified, was asked about video and said that he reviewed video. Now, this was not evidence that the Commonwealth intended on introducing or had any specific interest in. There was no particular discovery request by the defense, and there was no order. But upon reading that grand jury testimony, ADA Lally reports that he then inquired about the video.
Inquired of whom?
Trooper Proctor.
Okay.
This is shortly before trial. ADA Lally was given a copy of one of two of those productions. He was given the copy of the front wall video, which also contained video of outside the front of the police station. And that was quickly turned over after Attorney Lally received it on April 4th, 2022. So what we know at this point is Trooper Proctor has this original production on April 4th, 2022, shortly after January 29th, 2022. I'm sorry, it was provided April 4th, 2022.
2022 or later?
No.
It was later, right?
Was
Because
later.
the federal grand jury was there.
He provided it on the eve of trial. So it was April 4th, 2024.
Yeah.
So we know this production on April
Definitely didn't provide it in 2022.
4th, 2024 was in the hands of Trooper Proctor in shortly after January 29th, 2022.
So they know that this was in the hands of Trooper Proctor shortly after January 29, 2022, yet not turned over until the eve of trial. That's what I'm saying. Locked, loaded. It is a fact point. Intentional. To me, it feels like it's a fact that it's intentional, but even if you want to play it safe, this evidence was withheld from the defense in the constructive possession, custody, or control of the Commonwealth, the prosecuting attorney. No doubt about it. This evidence was suppressed and withheld from the defense. So the only prong that's really left is it materially exculpatory? That's really all the judge has to decide. If you could ask for partial summary judgment on a motion, this should get granted. He is admitting that right here, that that's exactly what Proctor did. But no grave concern from Bev. It really is crazy. No reprimand. No, I am not satisfied with your answer, Mr. Brennan. None of that. None of that. When this is so much worse then God forbid a defense attorney saying, hey, this cop seems like he's connected to the case. Why did he have access to the jury? That could be jury tampering. Like every defense attorney would say that. Very few prosecutors, I think, would do what Brennan's doing at this point.
At this point, the prosecution team is still unaware of the June 23 production, which has True Buchanan's name on it, which shows the
prosecution team is aware. The prosecuting attorney maybe is not aware. But the prosecution as a whole is aware, and Proctor has it. He requested it. He knows it all exists.
exterior sally port. As trial began, there still was no specific order or request. The chief of police saw something about the trial, and let me rephrase. Prior to the trial, it's reported that Attorney Yanetti was discontent because the video of the front camera sally port was so grainy, intermittent, and not continuous. And that's an accurate description of that video. Chief Rafferty, in response to seeing Attorney Yanetti's concerns, then asked Sergeant D. Gianpietro to see if there was another camera or to produce any other video from the sally port. Sergeant D. Gianpietro then downloaded video from the DVR, which is the second camera that is inside the sally port, known as the inverted camera, or now characterized as the inverted camera. That was produced April 23rd, 2024, given to ADA Lally, then given to the defense. And so at that point, there are 3 video productions that exist. The first turned over to the defense April 4th, 2024, the second April 23rd, 2024, and the June 23 production of the exterior sally port has still not been turned over. It's in the possession of Trooper Proctor, and the prosecutors do not know about it. After the trial, one of the employees from Norfolk County, Colleen Crawford, went to the sally port and looked at the DVR system. And when she looked at it, she saw that video still existed on that system. Although there was a 30-day overwrite on that system, the system had a number of backup hard drives. And because of the backup hard drives, the video existed longer than 30 days. She wrote an extensive report that was turned over to the defense. And this is after trial.
How? Did they say a video lasted longer than 30 days? How? Just a lot of information we don't know that feels like at least we need some kind of evidentiary hearing from my perspective. Karma, do you think Bev's unethically ruling over the trial? I don't know if you mean like because of some conflict. I've heard of that. I don't know the answer because I don't know all the details. Hank said all the DVR footage was on a backup drive around mid-2024. If it no longer exists now, is that destroying evidence? This is when we get into some difficulty because I don't know every single fact specifically. I don't know if he meant the videos that were around in 2024, we've turned them all over to the defense, or if some of them don't exist anymore. I'm not positive. I just don't see how a case where the car is essentially a weapon, how is messed up / lacking police video of the processing the car not exculpatory? So I can see how in some cases it might not be relevant, right? In some cases it might not be relevant. And Hank Brennan makes some arguments as to why it doesn't really matter or it's not material, which we'll talk about, that are decent arguments. With this degree of hiding evidence, repeatedly showing the failed to comply with their certification, how can the defense possibly ever trust that they have all the evidence and it will continue for other accused? They'll never think they have everything. And they have a reason to believe that because they already tried this case. This case should be over. There should not be 1 ounce of new evidence. And Hank Brennan makes arguments that the defense's theories keep changing. And, it's a moving target. How are we supposed to know what they're going to argue next? It's like, if anybody's theories are changing, you guys are the ones with all these new experts. And I have a feeling that the Commonwealth's case is going to be extremely different round 2 than it was round 1. So whose theories and whose arguments and facts are changing? If this motion to dismiss was never filed and subsequently argued, would we even have these reports that were just written or additional detail by Brennan in his timeline? You ask an unanswerable question, Amber, but I would hope all the reports would still be done and turned over if this stuff was actually happening. Don San Juan, thank you for the coverage. Love getting out of my echo chamber to see how less biased jurors will see things. I'm former law enforcement, and this case sickens me. On a scale of 1 to 10, is this worse you've seen in a criminal case? No. There have been worse, where I would say one of the reasons this is not the worst is because the defense attorneys are doing such a good job. I have seen criminal defendants get railroaded so bad. We have seen stuff come out where prosecutors get arrested, judges get arrested. They're putting people in jail to make profit off of private jail systems. There has been a lot of corruption. I don't want to say a lot to where like it's happening in 90% of cases. Most judges are good. Most prosecutors are good. So I'm not saying like this is the norm, but there are absolutely worse cases of criminal defendants getting railroaded where nobody's even really there to help them, which is the saddest thing in the world to see. Is it not having the complete video with metadata exculpatory because it could show manipulation? Watch for AI pop-up ad when Brennan displays a screen. I did see that. What does that prove? I don't necessarily know. And no, that's potentially exculpatory versus showing actual prejudice, right? Saying the camera's not there, judge, or saying something like, Judge, there's no camera on that house, and if there was a camera, it would show my client was innocent, does not prove that your client's innocent. So I get what you're saying, and I get the context around why we're kind of getting there, but K-Mac, will Proctor be a catch-all for the Commonwealth? This isn't the case with Bad Apple. It's an Orchard. I just don't see how he can be a fall guy for them because he's part of them. That's like cutting off your head and saying, I'm fine. We're fine, Judge. We can keep going. Has she ever given an instruction to the jury about quality of witness or evidence? I don't know what that means, but there is a jury instruction about judging the credibility of witnesses in this case. Yes. Patricia, you say often that the defendant gets the most benefit of reasonable doubt, but why is that most lawyers say judge or prosecutor bent? So they have to prove the case beyond a reasonable doubt. And there's a lot of rules that protect the criminal defendant and their presumption of innocence. But there's no doubt about it, most judges are prosecutor bent, and especially most criminal judges, because a lot of them were former prosecutors. And they probably see a lot of people that are guilty. And over time, they're human, and that's kind of how it's supposed to go in the brain, even though you're absolutely not supposed to do that. All right, let's keep listening to a little more of this.
The report notes her investigation about all the different videos, and it summarizes everything that she saw in that July 2024 visit. As I mentioned earlier, in August, Chief Rafferty provided video of the hallways that included some video of Brian Higgins, and she accompanied a letter or a note. I learned that video was copied during the trial, and it is noted in the sergeant's letter.
Copied how, by who, what does copying it do? How did they copy it? Did it destroy any metadata? Just a lot of questions come up.
The chief of police and the sergeant were downloading video, not in response to...
By the way, why was none of this put in an affidavit and filed? This timeline that he's arguing here as fact. He's saying these things as their fact, and we're going to move forward now as if they're fact, according to Judge Cannoni.
A motion to compel or produce, but rather because they had concerns about accusations that were being made about the department, and they were saving video, in their opinion or from their perspective, to help defend against future false claims against them. They downloaded a number of videos that were then turned over in that August 2024 production. When I first learned of that August letter and note, I turned it over to the defense immediately. The issue came up regarding the DVR in November, and as we've litigated extensively, so I'll simply summarize it, I invited the defense to come to the Canton Police Department. Given the intermittent or spotty production of video, I thought it best they have an opportunity to look firsthand, although I didn't know if the video would exist, as I said. And then when they came in December, I think it was December 12th, if my memory serves, and learned that there was no longer video stored because it had been overwritten, I then went to the Canton Police Department so that I could have a closer look at the video cameras to see if there was something missing. I toured the entire station. I learned about the videos. And then as a consequence, I spoke to the chief, other officers, and the sergeant unexpectedly. The sergeant told me that he would click and drag copies of video when he would download them from the DVR. Inevitably, we had the litigation about whether the defense was going to download in person or not. And then as I tried to finalize my investigation into the tapes and realizing there was no actual written chain of custody, I wanted best to memorialize it. I had been reviewing all files, data, hard files, but I had not been on the case long enough to review everything. So I asked that the parties of the Commonwealth look through all files, all databases, so that I could help facilitate my review. At that point, I was provided by Trooper Tully the June 2023 CD with Trooper Bennett's name on it. That is the exterior Sallyport video. And within 24 hours, I provided that to the defense. I then asked both the sergeant and Trooper Tully and Trooper Mechanic to write reports since there was no chain of custody. I wanted best to give as much information as I could and document the history of the video. That, Your Honor, is a summary of everything that I had learned, the investigation, and the production of the videos.
Do you know which investigator's file it was found in?
Trooper Proctor's.
Ouch. Do you know which investigator's file? Yes, Your Honor. In fact, I do know, and it's Trooper Proctor. Candy, Yeah, this is a very uncomfortable situation for any lawyer to be in, to admit to what he just admitted to. Adam, I think Crawford is the same person. I'm not positive. I'm sure the chat will give you the answer to that. Robin the Truth said, do you think Brennan effectively countered the defense? So effectively countered, I don't know. I mean, starting out with that big admission is not great. But I do think he picked the right legal argument, which is, Judge, this is not exculpatory. This is not materially prejudicial. This is not reasonably going to change anybody's mind or reasonably affect any outcome in this case. It's a red herring. That's what he said. And while a red herring might be a strong comment, he basically argues that they have the video now. We also have all these pictures and other videos showing the cracked taillight. So what is the Sally Port video going to show that isn't already there? We have people to testify about what happened. He talks about how, Yanetti said the CPD wasn't a crime scene. So it's not like we're talking about the crime scene here. The defense tries to conflate the two, but it's not true. He quotes Barros that says it's cracked and pieces are missing, or a piece is missing. And there's just nothing exculpatory about these videos. And if the judge buys that, he wins. So I think he picked the best argument he could have picked. Does that mean he's going to win? I don't know. You can't counter a lot of what the defense did, because this is bad. It looks bad. It is bad. It's not how it's supposed to be. Brennan even agrees with that. So when you can't counter that it's really that bad, it's tough to say that he did it. He had a good counter, but I do think he picked the right argument. So then he does show those clips and videos where the little AI editor pops up. And of course, everybody thinks that means they edited the video. I don't know. He shows a picture. He says, look, it was inverted before Karen Reed. And I was like, how did you get that, bud? How did you get that if it only lasts 30 days and then it gets purged? He shows other video that shows, the low quality of the video, and that's fine. And I get it. What I was waiting for is, show me a video where it just skips a chunk of time. Show me a video where it blurs people and they appear and disappear in different frames. He didn't show that video, and I was waiting for that. And that's the point. There were so many different problems with these videos that it's hard to believe it's just a quality problem, right? But did the defense actually prove that they were altered? No. How can they prove that? It's tough. It feels like an impossible burden, which is why the defense is arguing presumed prejudice, and I think they're right. But even with that, if Cannoni says, well, the Commonwealth overcame their burden and proved that it wasn't, in fact, prejudicial because of all this other stuff that existed, and that's how she rules. And that it really wouldn't make a difference to anybody if they would have had these videos earlier, and they fixed it with their cross-examination, et cetera, et cetera. And again, I've talked about how both sides can show the same picture and say, this very clearly shows lots of pieces are missing, 47 pieces. It very clearly shows only one piece is missing. He even agrees that it's hard to see some of this on the screen, which I thought was interesting as well. Oh, and then he talks about a comment Karen Reed made to Gretchen Voss in an interview, which I thought not great for Karen Reed and her team. So let's take a listen to this.
In fact, this whole idea of third party or plan doesn't come to town until 9 months after Ms. Reed is indicted. Perhaps the best evidence that contradicts the defense position that there's any relevance to the Sally Port video, that there's any type of plant by anybody, is from the defendant herself. Ms. Reed spoke to Gretchen Voss on June 20th, 2023. And in that testimony, or in that interview, she said, when my car was seized, there was a few small pieces of taillight missing that I had picked out at John's at 5:45 before we drove over to Fairview. I'm showing Jen and Kerry, look what I just did to my light. And I'm worried that there's gonna be some kind of electric short circuit. There's like the bulb is showing and some of the red plastic is missing. So I picked pieces out of the light housing that kind of collapsed within the light and dropped them in John's driveway. And so I say to the court, the production should have been sooner. It should have been cleaner. This should have been a log or an entry. Been sooner, driveway.
All right, so this is the kind of final admission, the wrap-up admission from Hank Brennan, which tells you, which again, he's admitting this because he's trying to win a legal argument about prejudice and the exculpatory nature of the evidence here. So he's admitting this, arguing it's not actually exculpatory, it's a red herring. But to me, this goes more towards the interest of justice and just how bad this is, that the prosecutor is sitting up there and admitting how horrible this investigation is. And if they could say it in trial, they would, the defense being like, even the prosecutor said this isn't how it's supposed to go. So if it's not going to get the case dismissed, this is definitely an argument for reasonable doubt, which if you have to admit this as a prosecutor, what are you doing?
And so I say to the court, the production should have been sooner. It should have been cleaner. This should have been a log or an entry. The failure to provide was inadvertent. It was unfortunate. It shouldn't happen. But it's not Brady. It's not exculpatory. It's not intentional. It's not tampered with. It was inadvertent and inconsequential because the evidence is overwhelming that that light is missing before the car makes it to the foot of the Sally port, so there can be no plan. That is my argument regarding the Rule 14 issue. I would like to.
So to me, it's like, so the judge is going to find that fact. The judge is going to look and say, and it almost does when he's showing the picture, she's like, yeah, I can see it. It almost sounded like she was agreeing that she could see the white light and, you know, clearly the 47 pieces were missing. But is she going to make that finding of fact that this was inconsequential because the video evidence was so obvious that the light was smashed in prior to it ever getting to the Sally port? So these videos are inconsequential and couldn't possibly be exculpatory. What are you even doing if you make that finding of fact? I just don't get it. Do you think the insurance money is why OJO's family wants Karen Reed convicted? No, I don't. Do you find it odd that Bev used to be a defense attorney and public defender yet leans so much toward the prosecution? So I don't know what Judge Cannoni's norm is. I know she ruled not guilty for a criminal defendant in a bench trial recently. It would not surprise me if this was a specific case-related type of feeling. I don't know. But there are also some judges that were defense attorneys then go prosecution leaning when they get on the bench too. Something that happens. I mean, most of the world is prosecution leaning. That's just the truth. Most of the world is prosecution leaning. Phil asks some unanswerable questions. Maybe we'll get the answer to some of these eventually. All right, there are two more clips I wanted to play. One is Jackson's kind of last ditch effort on explaining why, in fact, he believes that this is exculpatory. So let's watch that first. And then a clip a couple people are asking about, like Flummox Alessi. We are going to watch this clip about Yanetti at the end as well. Make sure you guys hit the like button if you have not already. We've got like 15,000 people in the chat. I'd love to get 15,000 likes on this video.
Disputed that the light was cracked. 5:07 or so a.m. That's how it got cracked, is the point. It got cracked on that traverse. And a piece was missing. A piece was missing. Not according to me, according to another agency's sergeant, Barros, who said a piece was missing, but it wasn't completely damaged. Recall that when that light was completely reconstructed with the 46, 47 pieces that were purportedly found, well, they were found at near 34 Fairview, and then they were reconstructed. Does the court recall what that reconstruction looked like? That taillight was put together almost in its entirety, almost, except
I feel like I keep saying prejudice when I mean exculpatory. So materially prejudicial, exculpatory, good for the defense. You know, I'm interchanging. It's late. I'm tired, but proving that it is in fact exculpatory and therefore Brady.
a piece was still missing. It was a piece unaccounted for. It's a big difference between a crack and the condition of that taillight, which we've now seen, where literally the entire lens material is basically gone. There's a few shards left on some edges, but the entire lens is basically gone. So yeah, it's relevant and it's exculpatory. The condition of that light when it pulled into the Sallyport driveway. And with regard to the inverted video, again, Mr. Brennan says there's nothing to see here. We've got inverted videos dating back days earlier. Then why, if that's such common knowledge, then why did Mr. Lally and Sergeant Buchanan in front of a jury present that video as a true and correct presentation of what that car looked like and where that car was? Mr. Lally actually asked the question. I don't have a page in sight now, but I remember it because I was sitting there. He asked the question. Did you see, Mr. Probably something I'm paraphrasing, something along the lines of, did either you or Trooper Proctor approach that right passenger taillight? And the answer was no, because on the video that was being played, it looked like the right passenger taillight was the one closest to the jury. And of course, Trooper Proctor walked right around that and went over to the other taillight. Except when you reverse it, you realize that's the right taillight.
Is there a copy of the reverse, the one that you played? Is that in the exhibits for today's motion?
No. The one that's been corrected?
Yes. I'd like a copy of
I
that.
don't think I have. Sure. We can get that to the court immediately. Also, he played a video of the grainy video showing, hey, look, some of these cameras are just grainy in other particulars as well, at other times and places. Maybe, or maybe not. What's interesting is the grainy video that we saw, if my memory serves me, and it's my memory, and it's being taxed at this point, but my memory is the chyron on that video, in other words, the running numbers, was at the bottom. That video he just played is at the top. That's the exact same video. It's apples and apples, oranges and oranges. Why is that different? That's interesting. And with regard to Ms. Reed's actual statements in that interview that was played, or I'm sorry, it wasn't played, it was recited. She said, some of the red plastic is missing. Some of the red plastic is missing. In other words, a piece is missing. It's completely.
And I don't remember hearing that in the first trial. I wonder if Lally was too scared to use it because the defense would say, yeah, that fits into our theory that it cracked in the traverse. I think Hank Brennan's going to use stuff like that. I think he's going to explain it, use it in his arguments to prove his theory. I don't think he's going to be as scared to use certain things that could kind of work either way, in hopes that a jury sees that as an admission. And I kind of think they could. After listening to some of the juror interviews and hearing what some of the jurors are saying, it is possible they see that as an admission.
Be consistent with the condition of that taillight before it was at the Sally court. With regard to the facts that were recited by Mr. Brennan at the very end, every one of those is unsubstantiated. How does he know all that information? Who has he been talking to?
This was also a really great point. Really great point. I didn't mention it, but Brennan went into this whole diatribe about how, they make an argument. At first it's planning an idea. Then it's finding the target. It's Fanning, who's such a great guy with a great reputation. And he talks about it being destroyed online and all these facts. It's like, where did he get those facts? And it's true. That's why we need an evidentiary hearing, not evidence coming from Brennan's mouth. That's just not how it's supposed to be done.
Those is unsubstantiated. How does he know all that information? Who has he been talking to? And why don't we know about it? If in furtherance of this motion, there was an interview done with Lieutenant Fanning that laid out all of this information about not having contact with jurors and not doing this and not doing that, but yes, doing this and that and the other thing, when's the first time I'm hearing about this when he stands up and tells us? That has been the pattern of this Commonwealth's presentation to this court and in front of the jury consistently. That is the punctuation mark at the end of the sentence. Why am I just now getting that? Why wasn't that appended to his motion? Was there a conversation Mr. Brennan had with Lieutenant Fanning that we need to know about? This is exactly why, Your Honor, exactly why. If this court is not inclined to dismiss this case, and it should, the maladies of the Brady concerning the Brady violations and the discovery violations are so manifold in this case. They cannot.
And he's right. We are going to jump ahead here a minute to Yanetti's argument. But he's right. It's just so bad. And we, at the very least, need an evidentiary hearing. Jessa Sayan said, could Proctor plead the fifth if there was an evidentiary hearing, given he's in his own IA investigation? Yes, somebody else asked this. If he thinks the answer or the questions are, or his answers could be potentially incriminating, yes, he could plead the fifth. Do you think other judges watch these proceedings and cringe? Brand New Nana said, if I had to guess, I would say yes. I didn't used to think people watched this stuff. And then I have people coming up to me now all the time in my life, and they're like, oh, I watched your video. I can't believe that's actually true. I can't believe lawyers actually do this. Can you believe what's actually happened to that lady? Can you believe what's happened to this guy? Oh, this person's so guilty. Kind of wild. All right. So then David Yanetti gets up to set the record straight because he said Brennan was making comments that Yanetti was saying things inappropriately out to the media because it was on court TV, when in reality, it sure seems like maybe they were just playing part of a hearing and Yanetti was actually making an in-court statement. Brennan doubled down. He said, I'd love to know your opinion at the end. David got the chance to tell the court about how Brennan lied about court TV, and Brennan just doubled down. Well, we're going to hear that exchange right now. Yanetti comes out big time on top, and I can't help but think if the roles were reversed, this would cause Judge Cannoni grave concern, because this is as bad, if not worse, than any misrepresentation that's been made about each other and about the lawyers and what they're saying about each other throughout the entire process here.
TV is not a courtroom.
So before you go further,
Yes.
I don't know if Mr. Brennan was going to give me a court TV site on that. Is
Right.
there one, Mr. Brennan?
I'll have to provide a video. I think that Mr. Yanetti is referring to that comment that was a court comment. And so I intend on remedying that record. There's also a
Brennan's like, I intend on remedying that record. It's like, when, brother? When? Because you said you had receipts. You should have already corrected that record. Because Yanetti's like, I have to stand up and publicly defend my honor, basically.
conversation after with court.
All right, so provide it to Mr. Yanetti. Mr. Yanetti, I'll give you an opportunity to respond once you get that. But go ahead, you can tell me what you want to tell me now.
Right now, it's out in the court of public opinion that I made this extrajudicial statement. I said specifically I did not. He contradicted me, and that's where we left it. And he said that he would produce the receipts. Now he's admitting he does not have the receipts. There was no court TV interview where I said anything of the sort. That was a Zoom hearing, excuse me, where I was.
And that's a problem. Prosecutors can't do stuff like that. You just can't be wrong like that. You really can't. And I hate that it's happening. Yanetti seems like a very pleasant guy. Doesn't seem like he likes to get into the mud and scuffle around very much, but he's right. Brennan's over there saying, you know, a lie that stays out long enough becomes the truth or whatever it is. And he's the one saying we're doing all this stuff in the media when in reality, he's misrepresenting things, knowing that the public is filming these hearings.
Arguing before Your Honor. You know, I would just note, Your Honor, you know, I don't think it makes sense that Mr. Brennan would have done this on purpose because it was so easily disprovable.
He kind of just said, I don't think he's that dumb. Is kind of what it sounded like. He wouldn't be that dumb to say something that's so obviously wrong on purpose, right? Yikes.
You know, it's troubling that he would make this damaging accusation without properly vetting it to see if it is true before he attacks opposing counsel. So that was disappointing to me. And I would just point out, and again, I only need 30 seconds. That,
You can take your time, Mr. Yanetti. You're not going to be
well, we're
45 minutes.
Right. I certainly will not be. You know, this new false allegation comes after my colleague, Mr. Alessi, co-counsel, Mr. Alessi, on February 25th, detailed 9 or 10 false statements that Mr. Brennan has made to this court. And I want to make it clear, I don't need an apology from Mr. Brennan. I don't expect one, but I think perhaps he should apologize to the court. He said today, a lie unchecked becomes the truth. And I just would hope, Your Honor, that you hold Mr. Brennan to the same standard that you hold the defense team. And that's it.
I certainly do. So, Mr. Brennan, if
You do, but doesn't feel like it.
you do not have a site, then I need you to let us all know that as well.
Well, it's convenient to retort that there were 10 lies by the court. Mr. Alessi lined up. In fact, I looked at the transcripts. Some of his suggestions that I didn't read the paperwork properly, which is wrong. I didn't try to shame him today. It was part of advocacy, and I accept that. There was a conversation, and if you remember, when I related to Yanetti's remarks, it wasn't in relation to 3.6. It was in relation to the fact that they were using the federal investigation to create a window that could not be.
You used it exactly like we all felt you used it. And it's always convenient when he's like, also, Mr. Alessi was wrong about a bunch of the stuff he put in there. It's one of those things like, I'm not going to tell you how I know this, or I'm not going to tell you who told me, or I know things. I'm not going to tell you, but just know that I know. That's basically what he's saying. It's like, why don't you tell us? Why don't you say, he's like, I'm not going to try to shame Mr. Alessi here today. It's like, he feels like the type of guy that welcomes disagreements, especially if it's something that he said and researched. But regardless, it is what it is. And that's where we are at the end of this hearing. Joe said, if Bev goes full simple Jack with no hearing, would this even survive on appeal? Godzilla size beat the rap, but not the ride. I mean, I never say something's guaranteed on appeal, and no defendant should say, oh, just let me appeal it. Let's go lose and I'll appeal. Appeals are so difficult. Just getting here from work, I heard there was a video showing the SUV backed into the Sally Port. Is this true? If so, would this impeach the Commonwealth stating Karen Reed backed into John O'Keefe? I don't think that there was any mention of this type of argument in this hearing, at least. Eric, they should put a flip chart with a timeline for every witness to fill out, and then during closing, compile a timeline to the jury, reinforcing it throughout. Could be cumbersome, but I don't hate the idea of timelines, and having an adverse witness do certain things sometimes doesn't always go the way that you want to and can really be clunky. John said, save for last, will there possibly be a Lawyer You Know March Madness tournament for the viewers? You can have as many participants as wanted versus fantasy football. It could be fun. Let us know. 100% we are going to do this. We're going to talk about it a ton in the March members only live. We did it last year. It was so fun. We'll do a prize again like we did. We'll probably do multiple prizes for multiple winners, but it's going to be awesome. I love March Madness. I got my Hard Rock bets ready, and we're going to roll. It's such a fun time. It's when I definitely watch the most non-FSU basketball, which this year it was kind of mid at best. So I'll be catching up and just trying to get lucky with the rest of us. That's all I got, folks. I got to get out of here. I'm tired. I'm going to Tallahassee tomorrow, do something really fun. I'm hopefully share it with you guys later. Seems like Brennan just says a lot of things off the cuff. I agree, Kevin. I get that vibe as well. All right. That's all I got. Till next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.